Afternoon. Good afternoon, everyone. Thank you for joining us. I'm Nuzhat Jaffrey. I'm the Executive Director of CCMW. We are just going to get started in a few minutes. We're waiting for more people to join, so just bear with us. We really appreciate your patience. Thanks. Good afternoon, everyone. Thank you for joining us this afternoon. It's great to see you all here today. So we are going to be engaged in a really lively conversation with our panelists. So once again, this is our seminar on Understanding Canadian Muslim Women Seeking Family Law Counsel. And this particular seminar is being hosted for community service organizations and the general public. So it might be slightly different than the one we held for law professionals or legal professionals, but certainly we're going to cover the same topics. So thank you once again for joining us. I'm Nuzhat Jaffrey, the Executive Director of CCMW. And we are here with you in partnership with the Community Legal Education Ontario organization, which is CLEO, the Barbra Schlifer Commemorative Clinic, the Canadian Association of Muslim Women in the Law, and Women in Law, and Access to Justice Week. So in collaboration with these organizations, we developed this 2-seminar series, and the aim is to share insights with lawyers and community workers so that you may be better equipped to provide services and supports to Canadian Muslim women who are seeking family law counsel. Throughout the seminar, please use the question and answer feature at the bottom. You'll see there's a Q&A symbol at the bottom of your screen. You can ask questions there, and we will have a moderated Q&A session after the panelists have completed their discussion, and Sabrine will moderate the Q&A with the audience using that feature. So I'd like to begin by a land acknowledgement. So I'm talking to you this afternoon from the traditional territories of the peoples of Turtle Island. The sacred land on which I share this platform with you has been a site of human activity for 15,000 years. This land is the territory of the Huron, Wendat, and Petun First Nations, the Seneca, and most recently the Mississaugas of the Credit River. The territory was the subject of the Dish One with One Spoon Wampum Belt Covenant, an agreement between the Haudenosaunee Confederacy and the Ojibwe and allied nations to peaceably share and care for the resources around the Great Lakes. Today, the meeting place of Toronto is still the home to many Indigenous peoples from across Turtle Island. as a Canadian Muslim woman, I recognize the connection between anti-Indigenous racism and sexism and gendered Islamophobia, and I'm committed to working toward justice for Indigenous women and girls in Canada. So, next slide, please. I'm going to give you a little bit of background as to why we're here for the seminar. So as I mentioned before, the seminar is part of CCMW's Legal Services Coordination program. It's the first ever Legal Services Coordination pilot program geared specifically to Muslim women in Canada. The program aims to provide culturally appropriate legal services, coordination for Canadian Muslim women who are seeking legal advice and counsel in family law. During the past several years, CCMW has undertaken initiatives to inform Muslim women, the legal profession, community service agencies, policymakers, and the general public about the differences between Muslim family law and Canadian family law. So I'm going to share a brief history of how we got to the current place. Next slide, please. So we've been tackling family law issues at CCMW for almost the last 2 decades. And we got involved in this issue because back in the early 2000s, we had a media call from someone who was interested in knowing about a lawyer, a Muslim lawyer who wanted to establish what he was calling a Sharia tribunal. And we didn't know anything about that. You know, we didn't know who the lawyer was. We didn't have any background. We didn't even know what that would entail. But I believe there was an article in the Law Times. And basically, the lawyer had proposed using the Arbitration Act in Ontario to set up such a tribunal. So we got very curious about that because we knew that there were a lot of family law issues that Canadian Muslim women were facing. And we said, oh, what would that mean for our constituencies and Canadian Muslim women and their families? So we started to do a lot of research, and we looked at what's happening in other jurisdictions where, family laws or religious or Muslim family laws are actually used, especially in some Western democracies, but also what was happening in Muslim majority countries. And we realized that we have to be very, very careful because the way the Arbitration Act was going to be used was that, whether or not the person was trained to do this or whether they had knowledge of Islamic jurisprudence or Canadian family law, they were going to be able to make arbitration decisions in family law that could be harmful to women. I'm not saying that they would always necessarily be, but we could see the potential. We saw some red flags. And we also didn't want to have sort of like a parallel legal system where Canadian Muslim women would be treated differentially from other women in the country. So we started to hear a lot of concerns about this from other women's organizations as well. And CCMW began a process of forming a coalition and a campaign to essentially disallow religious arbitration and family law, especially when the individuals making arbitration decisions were not going to be qualified to do so because they were not equipped with the knowledge or the experience to do it and had never really thought about the harms to women and their families. So we started this campaign. We were very vocal. We said that, if there were going to be if such thing or these kinds of institutions did exist, there would need to be a lot of education and the right people would have to do it. But really, the province wasn't equipped with any of that. So the McGuinty government at the time got a lot of pressure, not just from, we had a coalition of over 40 organizations, feminist organizations, and Jewish, Barbra was part of that, Jewish organizations who, they have their own sort of legal systems as well. So basically, the McGuinty government was hearing a lot of lobbying from all sides, of the spectrum, including a full-page ad in the Globe and Mail, or by prominent Canadians, saying, "Mr. Premier, what are you thinking?" So that happened on a Saturday or Sunday. Anyway, on a Sunday, the Premier decided, okay, enough is enough. I've heard a lot of clamoring about this. And by the way, we didn't come to our decision or our recommendation to the government just out of the blue. We did do a lot of research. We published policy documents. We did literature reviews. We looked at what was going on around the world. And we came from a position of evidence, because we like to recommend evidence-based policy changes. We presented that to the government, and we had a lot of supporters. So anyway, Mr. McGuinty announced that he was not going to allow religious arbitration in family law, and thus the changes were made to the Arbitration Act, and many other really good reforms happened in family law as a result of it, as well as a lot of education programs. CLEO was very involved in that education. We were very involved. To support the women in making the right decisions about which approach they could take or what they should know about their rights, we asked two scholars to prepare a comparative primer on Canadian and Muslim family laws. So Professor Linda Clark at Concordia, who's an Islamic scholar. She is a scholar of Islamic jurisprudence and it has a lot of experience working in different Muslim majority countries, doing her research there. And then, of course, the other person who was very prominent in our work was Pam Cross, who is by far one of the experts on gender-based violence and family law. So they put together this primer. And the primer formed the basis for community booklets that we published on each of these topics that you see on the screen, such as divorce, marriage, domestic contracts, custody and child support, family property and spousal support, and inheritance. So and these, in the initial booklets we actually published were available in multiple languages. So we did a lot of workshops, we did a lot of education around that material. And believe it or not, that was more than 15 years ago that we did all of that. We also developed a sample Muslim marriage contract, and it became a very popular item. You can download it from our website. It's just a sample for you to base your marriage contract on. And in Islam, marriage is just that. It is a contract between two parties. And so there's some really, interesting provisions in there, and you can modify it according to your particular needs, the spouse's, needs and wishes. But it would become a binding contract if both parties were signed, if it was available in writing. So, it's a good item for you to consult, and you can download it from our website. Over time, what we noticed was, we were still getting a lot of calls from people because there are lots of people who have arrived in Canada in the last 15 years or so, especially because of the, refugee situation around the world. A lot of Muslims came here, and we found that we needed to update the information we had published previously. So we engaged Pam Cross again, along with another Islamic scholar, Omar Farahat, from McGill, and they reviewed the contents and they updated the contents based on what was happening internationally with Muslim family law, as well as in Canada with changes in the family law regime in our country. And then we published these booklets or updated booklets. Unfortunately, we could only do them in English and French. We applied for money to get them translated. We did not succeed, but we welcome any support you may have to publish them in other languages. So we did that as part of our Canadian Muslim Family Law and Legal Rights project, which was funded by the Law Foundation of Ontario. And incidentally, this pilot program for legal services coordination is also funded by the Law Society. So as part of this pilot program, we were asked by we said to the Law Foundation that we would have these educational seminars or workshops. So here we are. I hope I didn't take too long. I know the history is long of how we got here, but we're glad to have landed here, and we're so glad that you joined us. So I think a lot of you may or may not know about CCMW. CCMW is a national charitable organization that has been around for almost 40 years. Next year is our 40th anniversary. We have 15, 16 chapters across the country. They grow, they've been growing. And they are of varying sizes in different cities across Canada. And we take on many, many different projects, and our commitment really is to improve the lives of Canadian Muslim women and girls. And we work at it every day. So I'm going to now pass the mic over to Sabrine, please. Sabrine?
Hello, everybody. So very happy for everybody to be joining us in this seminar. We have some exciting panelists and some great questions. I think I can go to the next slide here. And I just wanted to thank, of course, the Law Foundation of Ontario for funding this project, the Barbra Schlifer Clinic, whom we work very closely with, CAMWL, as well as Access to Justice Week, which is a part of TAG. So those are our partners, and we thank them. And Nazhat, would you like to introduce the agenda?
Sure, I can do that. So I know I've already taken up a lot of your time, so we're going to get into the panel discussion quickly. We are going to have this amazing discussion with with two amazing lawyers and an imam, Dr. Timothy Giannari. And then Barbara Landau will tell us about alternatives to family court. And then we'll open it up, or Sabrine will moderate the Q&A the questions that you're going to be asking using the Q&A button at the bottom. And then we'll have some closing remarks. All right, so let's get started. I'd like to begin by welcoming our panelists, Aisha Amjad, Ghania Bukhari, and Dr. Timothy Giannari. Just a little bit about our panelists. Sorry, can you go back? I'd like to introduce Aisha. Aisha Amjad is a barrister and solicitor practicing in Toronto. She obtained her honors Bachelor of Arts degree from the University of Toronto and her Bachelor of Laws from the University of Windsor. As a law student, Aisha taught first-year criminal law tutorials for Professor David Tanovich. Aisha also worked as a research assistant for Dr. Julie McFarlane, where together they collected the first empirical research of Islamic divorce processes in Canada. And in fact, that's where I met Aisha for the first time, and she was doing this work with Julie McFarlane. After law school, Aisha completed her articles of clerkship at the prominent criminal law firm La Fontaine and Associates. Aisha was called to the bar in 2011. As a lawyer, Aisha has appeared before the Ontario Provincial Court of Justice, the Superior Court of Justice, and the Ontario Court of Appeal. Aisha practices predominantly in family law. She helps families navigate through the separation process by providing support and legal guidance. Next, our next lawyer on the panel is Ghania Bukhari. She's an advocate for survivors of gender-based and sexual violence inside and outside the courtroom. She currently works as a staff lawyer at the Barbra Schlifer Commemorative Clinic in Toronto, where she provides legal services in the fields of immigration and refugee law, family law, and sexual assault law to women survivors of gender-based violence. Ghania served as one of the Law Foundation of Ontario's Public Interest Articling Fellows and completed her articling fellowship at the clinic. She attended the University of Ottawa Faculty of Law and has extensive experience providing legal services to vulnerable populations across Ontario, including survivors of violence, refugees, self-represented litigants, and individuals experiencing multiple and intersecting marginalizations, such as poverty, homelessness, discrimination, precarious immigration status, etc. Ghani's legal practice is grounded in a trauma-informed, intersectional, and anti-oppressive lens. Next, our panelist is Dr. Timothy Giannari. Timothy is actually from Toronto, but right now he's in Chicago, so we miss him here. He is the new president of the American Islamic College, as well as a member of the academic faculty there. Dr. Giannari is an accomplished scholar of classical Islamic theology, philosophy, and spirituality with strong interest in Islamic psychology, moral theology, ethics, political thought, comparative religion, and spirituality, and interfaith relations. More specifically, he's a scholar of Abu Hamid al-Ghazali, one of the most important religious thinkers of the classical period. Dr. Giannari is also recognized as a Muslim theologian, pastoral leader, and committed interfaith advocate, and with extensive experience promoting interfaith engagement around the globe. So welcome to the panel. And we're going to open with a question for each of you, and you can answer. Maybe the first panelists who can address this question are the lawyers, but maybe Timothy, you can also provide some insights. So could you describe for us some of the limitations and the gaps that exist in serving Canadian Muslim women who are requiring family law counsel? Rania, do you want to go first?
Sure. First of all, I just wanted to say thank you for the introduction and the invitation to speak today. Our last seminar was really interesting and sparked a lot of really thought-provoking discussion. So I'm looking forward to continuing the conversation today. I just, before I answer the question, I do want to just explain that as a lawyer, my primary clientele is or my only clientele is survivors of gender-based violence. And so I am going to be talking about how to provide service to that specific community, and what, Muslim women who are experiencing or have experienced violence, what their experiences are like and how to support them. But I just wanted to say that that's not something that gender-based violence is not something that is particular to any cultural, religious, ethnic, or any particular community. It's a problem that affects all communities, unfortunately. So in terms of the issue of access to justice limitations or barriers that Canadian Muslim women face in seeking family law counsel, I think there's a lot. The first one, I think, is a lack of knowledge about legal rights, both under Islamic law as well as what the Canadian family law system offers. In terms of their lack of information about their under Islamic law, I think there's a lot of reasons for that. I mean, one of it is there's a lot of misinformation that's peddled either by abusive spouses to kind of justify the abuse, or kind of they use that misinformation as kind of a tactic of manipulation. And then there is a lot of, I think, reliance on these community elders or senior members of the community who don't necessarily have like proper training in Islamic law, Islamic jurisprudence, and these people have a lot of weight is given to their opinion and what they have to say. For Muslims that are Muslim communities located in rural areas, or that are geographically isolated, or that are just smaller communities, there also might not be like a diversity of religious thought that's represented in the in the religious authority. So there might just be one imam or two imams that might not be able to offer a diverse perspective of Islamic law. In terms of Muslim women that are experiencing family violence and abuse within their relationships, I think one of the main barriers for them to seek help is a lack of financial resources, and a fear of poverty. And we do know, like, there actually is data to show that post-separation, there is this concept of feminization of poverty, which basically means that women are at a higher risk, women and children are at a higher risk of facing poverty upon separation and divorce. And there's a lot of reasons for that. It could be that they're coming into the marriage with very little, or they choose not to work, or they're prohibited from their partners from working as a form of abuse. It could also be that they now have they take a majority of the responsibility of taking care of the children, so they have that responsibility as along with their career responsibilities as well. And I think it can also make it really difficult for women that are experiencing violence to reach out for support. There is definitely a social stigma that's attached to experiencing domestic violence. There is, a fear of disclosing the violence to, family members, friends, the community, a fear that leaving the relationship and people the community finding out that there was the woman experienced violence, there's a fear that the woman will be blamed for it, or that she'll be encouraged to return to her abuser. And just the last thing, the last two things that I think are really important for us to mention is that I think there is also a fear and a distrust of government institutions and the state, specifically going to the police or not believing that the police will be able to help, or that they'll minimize the issues, or that they won't offer them practical solutions to address the safety concerns. And I think that fear is happening in a context of Islamophobia and hyper surveillance of Muslim communities by the police and by the state. And for Muslim women that are migrants, who have migrated to this country, that fear can also be amplified by an additional fear of deportation, or a fear of immigration consequences, a fear of reaching out to the police, who will then flag Canadian Border Services about clients like lack of immigration or precarious immigration, and that leading to some sort of removal. There's also a fear of retaliation from the abuser if the woman's immigration status is dependent on their partner. So for example, if the partner has filed a sponsorship application, and there can also be language barriers as well that can really inhibit, if someone doesn't speak English or French, it can make it really difficult for them to seek help, seek services, not just of the state, but also other organizations, homeless shelters, women's shelters, clinics like the Barbra Schlifer Clinic.
Great, that was a very comprehensive response, Khania. Does anyone want to add anything to what Khania has already highlighted in terms of gaps or limitations in the legal system?
Hi, thank you, Nazat. Thank you for the introduction as well. I think, Anya, you pretty much covered it in terms of listing off all the barriers that women feel when accessing the legal justice system. I think from my perspective, because my practice does include a very large Muslim population, both men and women. So I think that what I hear constantly is being able to find a lawyer who is culturally competent and who understands some of the values that they're coming to me with. And my experience with working empirically with the research with Julia McFarlane is it sort of amplified to me that many men and women, there's still a big part of them that wants to make sure that they're doing things the Islamic way and whatever that means to them. So just being able to have those conversations with them and how that intersects with Canadian family law and their rights under Canadian family law. So just being mindful of that, just being mindful of the person that's coming before me, the values that they're bringing to me, and also in terms of the decision making, is it things that are influencing them, whether maybe people or the community. And I do find that it's unfortunate, but there is that stigma that associates with Islam and divorce, and that is something that I find that I have to sort of work through with my clients, because by the time they come to me, or they should have already made up their mind, because it's really not my role to help them decide if they're going to leave. I can just point out the factors that, happen post separation. But I do wish that there was more community support, with making them feel that they're going to be okay. They're going to be okay once they do take this step. And I find that for me, practicing, I'm always searching for community members who I know who have who kind of share the same goals, as I do, in terms of just making sure that the people are safe, making sure that they're given that support. And even if it means knowing, like, we used to have this term when I was working with Julie, that many women did imam shopping, right? They wanted to just find the right imam that would give them that assurance that they were allowed to take the steps that they were taking. And I find in my practice, it helps to have a roster of those imams that I know that if I did send somebody to have this conversation, that they would be in good hands. So just from a community perspective, just being able to put this roster together, whether it's social workers or imams or therapists, who could sort of help in that separation process, is super helpful.
Great.
So.
Thank you, Aisha. Anything else, Timothy?
Yeah, just a couple of things. I want to again thank the Canadian Council for Muslim Women for all of the the life-changing, life-transforming, and sometimes life-saving work that you do. And I just want to, I don't think I adequately, thanked Rania and Aisha last time we were on call, but it's such a privilege to be with you. And even though I come to this not so much from a vantage point of a professional who is working with these issues legally on a daily basis, for whatever reason in life, I've had the privilege of walking with many traumatized souls as they've sought healing and sought help, and in those contexts, the injustice of male privilege sometimes within an Islamic environment can be a helpful factor in terms of allyship and I guess advocacy for people in these very vulnerable places. And so I just want to acknowledge both the injustice of the patriarchy that we live in, and also the importance of men becoming allies of women in these situations, because it's important. I just wanted to add a couple of things. One is that we should not assume that all Muslim victims and survivors of sexual violence are married, right? And so I have one woman that I've been working with over the last many months, is a survivor of rape, but the rapist uses informing her family about the event as a weapon of manipulation and control, because she's terrified of how her family would respond if they even knew that she had been intimate with a man outside of marriage. And so I just want to also, part of the I guess the limitations that Muslim women face are the attitudes within the family and within the community about sexuality and outside of marriage, and so that can be a debilitating factor for many women who should be seeking help, but who are afraid to seek help, because if this becomes a legal issue, for example, if they talk to Aisha or to Rania, then if it's a legal issue, it becomes a public issue. And if it becomes a public issue, it becomes a family issue. And many of these women live in terror of family members being made aware of what they have endured, even though what they have endured is in no way their fault or of their making. Another factor I think that we need to bring up, I think, Rania, you were absolutely right that that living within an Islamophobic context sometimes makes people, more fearful of trusting the authorities, or more fearful of making this a public issue or a legal issue, because either the imams who are counseling them, or or their families or others, are worried about feeding the fires of the dehumanization of Muslims, or the misinformation about Muslims. But I think also we have to acknowledge within immigrant families and immigrant communities, that the distrust of authority really begins in the country from which their families have immigrated, because of the corruption and the toxic patriarchy that can exist in those environments, and the way that sexual shame can be used as a as a weapon. And so again, sometimes it's not the mistrust of Canadian authorities isn't always the result of Islamophobia in Canada. Sometimes it's the result of having a profound mistrust or distrust of government and of police from our traditional environments or the countries of origin. And in a country like Canada, it becomes amplified because these people aren't even culturally or religiously the same. And so I think we have to acknowledge that immigrant experience as well.
That's great. Thank you. Really, comprehensive responses from all of our panelists. There's a curious thing that I've experienced in answering our phone for CCMW. We'll get inquiries from women who say, I need a counselor, or even a lawyer who's not Muslim, but particularly therapists and counselors. They want to talk to a non-Muslim. And I think that may have to do with the, community shaming and community pressures, or not others finding out from another Muslim that this individual is seeking help. How would you address that issue? Because it's a real issue. I've answered many calls like that. Anyone who wants to take that on?
I think from my practice, I really go over the privilege between myself and the client. If they decide to be my client, I go over how any conversations that they have with me are considered privilege, and I would not be sharing that with anybody. So anything, it's just very important for them to be mindful of that, so that that they understand that it's really upon them to share anything that can get back to anybody else, but it's something that I wouldn't be sharing with anybody. So I just remind them that the importance of privilege. And I think with me, by the time they get to me, they could tell by my name, that I am identify as Muslim. So I think they've already made that choice, but I have heard that before. I think people are just sometimes a bit nervous that information is going to get passed around, or maybe even as they're telling me, what is she thinking? What is she thinking of me? And but I think from my role, from my perspective, when someone comes to me as a client, like my gears are just so focused on the legal issues that they're talking about, that it doesn't really go any other way. There's really no other way for it to go.
And really when we sort of talk to them and we say, well, yes, there are Muslim and non-Muslim practitioners that we could refer you to, but then we sort of, unpack what their fears are, and then they move forward or not. I have another question now that relates to, so, maybe some of the audience can answer this in the Q&A or in the chat. What are some steps that organizations like Barbra Schlifer is a very good example, that you take to ensure that there are culturally appropriate services being provided? So how do we gain cultural competence in whether it's a legal profession or social work, or even at the American Islamic Institute? Because as we know, one of the biggest issues that we encounter with respect to the women that contact us is the diversity within the Muslim communities. You know, there isn't a one shoe fits all. In fact, there isn't any for any kind of women's services, but it's all the more acute for Canadian Muslim women. So how do you sort of prepare for that, for the diversity, for the cultural competence, knowing that there are a lot of differences? Khania, you want to take that first?
Sure. I mean, I think it's a complicated question. I mean, I do think that it is the responsibility of any organization that's providing service to, you know, to the public, to be able to ensure that they're also providing their staff with that kind of training. So I know that, for example, in our office, we have had trainings on anti-Black racism. We have had trainings on how to provide support to members of the LGBTQ plus like population. In our office, we also, we have this model of practicing from an anti-oppressive lens. And basically what that means is having, number one, an understanding about the history and systems of oppression. So, you know, like, for example, colonialism in Canada. So understanding the history of it and understanding the legacy of it, how it manifests today, how it impacts, you know, Indigenous people in Canada today. And then once you have that knowledge, it's a commitment to not recreating the same pattern of oppression that a client would experience, like, you know, dealing with the state in that kind of interpersonal relationship or in the service delivery. So part of that is being really self-reflective and self-critical about, like, the, you know, identifying biases and prejudices, and actively working to challenge those or eradicate those. And I think the other part of it is the way I see my role as a service provider is ultimately the decision is the client's. My job is to give them information and legal advice so that they can make an informed decision. Whatever decision that they make, if I personally agree or disagree with it, that's not relevant. It is really about the woman exercising her agency and autonomy. And for our clients, because they have not, you know, in the relationship of abuse, they have not had that agency and autonomy. It's really important for the service provider to respect that, and you know, to you know, facilitate the outcome, whatever outcome the client wants, to facilitate that, you know, for their, obviously, you know, within reasonable limits. Obviously, as licensed professionals, we do have certain professional responsibilities and obligations, and keeping those in mind. So yeah, I do feel like, just to sum up, I feel like, you know, as system actors, as organizations, as agencies within the sector, I think there is kind of a agency responsibility, and then I think there is a personal individual responsibility as well.
Great, thank you. Anyone else want to comment on that? How you ensure? I mean, Timothy, this is a different kind of question for you, but in essence, you are a community service provider, catering to a diverse, you know, community.
You know, I think that the point about restoring a sense of agency and autonomy to the person who's in that vulnerable state, I think that all real therapy and all real healing and emergence from these theaters of trauma and vulnerability, all of them require the restoration of agency and autonomy to the person who's making that, courageously facing what's happened and making that journey. And so I think that that's just so critical. And so in that way, the client is really the teacher of the professional, whether it's a psycho-spiritual professional or a legal professional. The client is the teacher of the person who's seeking to serve them and to equip them with as much knowledge and as many tools as possible. And so you know, within the religious framework, then there are, of course, so many denominations within denominations and interpretations some of the interpretations are certainly cultural overlays, and those have to be sort of gently clarified and teased out. But at the same time, it's absolutely true that the client's agency has to be the client has to be really at the forefront of the process. And so that means that we're serving that person in this state and not wielding our own power, right? It's not about that. And so it's really, I think that was just such an excellent point, Ghania, that restoration of agency and autonomy is just so critical. And then when the client is leading the process, then we whatever we're offering has to be kind of in conformity with where that person is and where that person wants to go.
Great, thank you. Aisha, would you like to add anything else to what we've heard?
No, I think both Gania and Timothy, they covered it very well.
Nusrat, sorry, I just wanted to add one more thing, which I just thought of while Dr. Timothy was speaking. I think part of the competency aspect of it is also recognizing when you are not competent as a service provider to provide the adequate services to that client. And I think in that situation, it is your responsibility to constantly do that assessment of, is this someone who I can provide competent service to, both culturally, but also in terms of dealing with the legal issues. And in that context, I think it's also important to provide the client with appropriate referrals or somewhere where they can get that competent service.
Yes, very good points. Great. So now we're going to move on to the topic of marriage. We're just going to sort of tease out a couple of things that keep on coming up when we hear from women. So there's two things that we hear from them. One is that they want to have an Islamic marriage, and the concept of nikah as the marriage contract, what it really is very, it's not always understood. But so the idea that here, the marriage has to be registered officially. So some of them will say to us, I want to get married Islamically, but I don't want to have my marriage registered. So first of all, maybe I'm going to ask you, Timothy, to explain the idea of the nikah or the Muslim marriage contract. And then how do you respond to someone who says, I don't want it registered?
Well, it is, sometimes contract is I know that, I'm in a legal room here. And so contract is the right word for the nikah document. But I think contract does not capture the holistic nature of marriage and intimate partnership. And so I think that when we're talking about marriage, it's important that we talk about it in a fuller psychological and spiritual context. And as I tell young couples as they're preparing for, especially young couples, as they're preparing for their first marriage, that this is the most difficult thing you will ever do. And if you were training for a marathon, you'd have a coach, you'd have a special diet, you'd have some days where you run, some days where you don't. You'd have a whole system laid out. But for some reason, when it comes to marriage, Muslims think they can just call an imam and get married in a day or two, and it's easy, and that we automatically know how to do it and how to manage it. So I think that within a Canadian context, warning flags always go up if a couple approaches me and asks me if I'm available just to do the nikah, the Islamic religious service. And they don't want to have any kind of provincial legal recognition of the marriage. And one of the main reasons why that creates concern and a sense of foreboding in me is that it really means that especially the woman going into the marriage is going in with less protection than she would have if it was official. There's also the possibility of secrecy, of this sort of flying under the radar, and it makes me wonder, what kind of histories I'm dealing with. And so, and for me, I would never agree to do any kind of marriage without, months and months of notice, so that there can be a whole series of conversations and explorations of histories and other things coming into it. But the danger, especially within the Canadian context, is there's, of course, the danger of illegality. There may be another marriage in another country somewhere that we're unaware of, and that they don't want to have investigated, from a legal lens. But then there also is just the possibility that one of the two partners is not taking this very seriously, and that especially the woman in this situation may be less entitled to protection and to rights than she would be if this was a provincially recognized marriage. And so even now, when I'm no longer on the books as a recognized marriage officer in the province of Ontario, if people want me to perform the religious aspect, then I always have someone else, another person in Canada who has that number, and I have someone else working with me so that we can make sure that this is a legally recognized, a provincially recognized marriage, in addition to the religious service. And so I think for me anyway, when someone approaches me wanting only the religious service, I think lots of warning flags go up, and then it's a cause for investigation.
Great. Any further comments from the other panelists on this particular issue?
I was going to add that, so if the marriage isn't registered, then the couple is essentially considered common law. And for common law couples, they don't have the automatic right to property upon separation. And what that means is that that if the two of them, let's say they were living in a home together, that home doesn't automatically take the characteristics of a matrimonial home, and therefore neither party can treat it as such upon separation. There's still the remedy, an equitable remedy that parties can seek if they've contributed money towards the mortgage or the finances of the home, and they would be seeking with an equitable remedy from the court for that. But it just limits them in terms of what they can do if they were separated. So from my perspective, that's really important to note as well.
Very good.
If I can add one more thing, that even when we're dealing with a provincially recognized marriage with the equalization of property rights, I've been invited into situations where even with all of those protections, the woman still is on the losing end of the marriage negotiations, because he's been crafty about how he's been able to hide his resources, or the woman is still facing poverty, and rather than get nothing, and has no money for a lawyer, and rather than get nothing, she'll at least settle for something from him and sign the documents, because she's still, poverty is still being used as a weapon of intimidation and manipulation, even when the marriage is provincially recognized, and she is entitled to an equalization or an equal share of the assets of the husband and of the family. So even with all the legal protections, as you guys are lawyers, so you've seen many more cases of this than I have, but I've seen several cases already where even with those protections, the woman is still those fears are still being wielded as weapons. The fears of poverty and other things are being used as weapons to manipulate and to compromise the woman's rights.
Absolutely. I think for me, in my practice as a lawyer, I try to, in my initial intake, I try to really understand if there's a power imbalance at play and what that looks like. Because a lot of times I have women who say to me, well, I've never paid anything in the house. Like I never made any of the mortgage payments. I never paid any of the bills. So he's saying the house is his, so I really have to unpack that and sort of inform them of their rights, irrespective of whatever they have or have not contributed, to go through that. But one of the practical challenges that does exist, Timothy, it kind of goes to what you're saying, is that when you own property, the matrimonial home, you own property, you don't automatically qualify for legal aid. And that's a big problem, because then what happens is that it's just another hurdle to go through, right? And you have to, legal aid may sometimes take you on and then put a lien on your house, in hopes that it's going to get sold. And then it's just a practical reality for some of these women that I see. So for me, in those situations, it's really about strategizing and putting together a plan that's going to bring them in a situation where they are, I guess, not just in a place of power, to have those negotiations. And so that's sort of, for me as a lawyer, that I do have to do with some of my clients, because they're not in that, they don't have anything, right? They don't have the legal aid certificate. They don't have any access to money. They own property, the property that, they could be living in a $1.2 million house with not knowing, how am I going to make this happen? How am I even going to get half of it? Who's going to leave? Am I going to stay in here? Is he going to leave? So it really is, it's just planning and going through, going through their case, like specifically, by case. It's not just like a one solution for all, right?
Great. Thank you. Rania, I guess you've covered the ground on that one. Should we move on to the next topic? I was going to talk about, specifics in our sample marriage contract, but maybe things will come up as we go along, because another hot topic is the mahar, which is actually part of the, Muslim marriage. There's a stipulation for a certain amount of, they call it the dower or dowry, but it's in the contract, it's known as the mahar. So Timothy, if you could explain for our audience, what is the mahar exactly?
It might be helpful to start with what the mahar is not, right? So the mahar is not a bride price. So there is no financial payment for the husband's use of his wife's body or any of those things. So there's no, or the servitude of a woman entering into a marriage agreement. So the mahar really has always been understood to be a recognition of the fact that going into the marriage, there is a particular kind of vulnerability that is shouldered by the female going into a marriage agreement. And so traditionally the mahar then was meant to be like a nest egg or an insurance policy for the woman. This would be something that would be her own, that the husband would not have access to, that something that would not be used for the daily bills or the maintenance of the family, but this would be something which would engender a sense of security in the event, God forbid, that the marriage failed, or in the event that something were to happen to the husband. And so this is not given in exchange for consent. It's the only question when I do a nikah. It's the only question that I ask the bride that I don't ask the groom, because I think in this day and age we understand that both partners are coming to the marriage freely, God willing. Both of them are coming without compulsion. Both of them are offering themselves to the other, and a real marriage requires that they both accept that offer of the other. And so it's not just about the woman being offered with her consent to the man and him accepting it, as is traditionally regarded. I think it's understood that both are really offering themselves to each other, and both have to accept that. So the mahar then, if she's accepted the mahar that he has prepared, I think this is the only question really that I ask her that I don't ask him in the course of an Islamic religious ceremony. And the mahar, of course, for in this day and age, it's quite possible that the bride out earns the husband, that the bride doesn't have need, let's say, of that kind of financial security. And in those situations, it's entirely possible that the mahar would be symbolic, that it wouldn't be necessarily something of monetary value. And also when poor couples are getting married, marriage is not just the right or the privilege of the rich. It's for all people. And so couples that are struggling financially also may have a much more modest mahar, but the intentionality of it is, I think, important always to talk about. And it's also important that a couple be coached in that process, because it's not like, yeah, I want 10 grand from you or else I'm not going to marry you. That sounds pretty crass, and it is. I mean, that way of thinking. But I think one of the sweetest examples of a mahar that I know of was from a young couple that was talking to me about, they were childhood friends, their families were close, and he wanted that security so badly for her that his mahar was that she was going to get a percentage of his net income for the rest of his life, for the rest of his earning life. And that would go into her own account, and that would be her nest egg, because he wanted that security for her. And that was such a loving and beautiful gesture. And I've witnessed many loving and beautiful gestures of the mahar, but that really captured the spirit. It was a spirit of loving concern and a spirit of wanting security for that partner, and wanting that person to be in a situation where they were not vulnerable, and they were not in a state of panic, or that they would be really secure in this new life together. And so to me, that's what the mahar is about.
That's really interesting, because oftentimes, people will talk about an exact amount, and they'll be negotiating the amount. It becomes like a bargaining kind of tool in the process, often between the families, not so much between the couple. So it's interesting. That example is it really is sweet. So I think we're going to move on to some other questions related to the mahar. Maybe this is for the lawyers. How has the mahar played out in Ontario courts or in the courts generally? Could you please talk about that? What does the case law say? How do judges treat the mahar? Who wants to start? Aisha, do you want to take that first?
Sure. So in case law in Canada, there are cases where the mahar has been recognized as a valid term of a contract, and the courts really look at the contract to see if it includes the other elements required to make a sound contract. For example, if both, if the contract was in writing, if it was, if there's, clauses in there that say that both people are signing it, with their free will. If it's clear, if it's not vague, if it's exactly been, the terms of what is the mahar has been clearly identified. Courts look at that. So there is case law that suggests that courts will enforce it as a part of a valid contract, but it has they really just look at whether the other elements of a contract exist. Gania, do you want to add anything to that, or?
No, I think Anya, do you want to? Sorry, go ahead, Anya.
The only thing that I was going to say is, yeah, I mean, the courts want to see the formal requirements of the contract law being met. But I think the court is also looking at other factors, like if there is undue influence, or one party has misrepresented the facts, or one party has failed to disclose significant assets. Especially if there's children involved, the court's analysis then shifts to what's in the best interest of the children in kind of making decisions as well. So there's a bunch of factors that the court is looking at, but yeah, I mean, the consensus among the court is that it's seen as a contract, like a contractual clause that is enforceable that way.
Yeah.
Great. Thank you. So one other question that comes up is when the mahar is due. So I know that it could be deferred or it could be immediate. Can you explain that, Timothy?
Sure. It's not required Islamically that the husband have, or the groom have the entirety of the mahar in hand, at the time of the wedding. And so sometimes a couple will have either part or all of the mahar deferred to be paid at a later date. But that still is a binding obligation on the part of the groom going into the wedding, is that this is part of the marriage contract Islamically. That said, I do know of some imams who have performed Muslim marriages where the mahar was stated but not written down. And if it's not written down, it's really not enforceable, and unless there are witnesses to that verbal contract. So I know of scenarios where a husband flipped shortly after the marriage, and it became bad very quickly, and the mahar, which had never been written down by the imam who performed that marriage, was never retrieved, right? And so and again, it was a scenario where the marriage was not recognized, it was not registered provincially, and so it was that promise was unfulfilled and lost completely. And so at least when we think of the welfare of the woman in that situation, so it is possible for the mahar to be deferred. And so that said, I think that, and one of the things that Aisha brought up last time is that, or maybe it was a Ghaniya, but one of our lawyers mentioned that still is understood to be a binding legal part of the legal obligation of the husband, even if it was not paid up front. And so it's just one of these, I guess, legal tools within Islam that would make wealth not a precondition for marriage. And so the promise can be made as a solemn promise. And I always tell people that if they're doing the religious ceremony, it should be very explicitly written. And I always tell a couple, if they're shy about the public proclamation of what the mahar is, I said, well, people don't really need to know. It doesn't need to be proclaimed at the wedding, but it does need to be written on the contract. And so that's something that I insist on.
Great. Well, this is a topic that needs a lot of time and lots of exploration. So maybe there'll be more questions about it from the audience. Now, I'd like to move on to divorce. So there's again a few things about divorce that come up from the Muslim women that contact us. But before we talk about those very specific issues, I wanted either Ghaniya or Aisha to talk about the latest amendments to the Divorce Act, their significance, and also both any challenges for Muslim women or actually, facilitating features of the amendments for Muslim women. Can you, who wants to take that on? Maybe I'm going to look at Ghaniya, because there's such a lot of provisions there on gender-based violence. And then I'll come back to you, Aisha.
Yes.
Sure.
Yes, absolutely. So just for some context for our attendees. So the Divorce Act is the federal legislation that governs married couples that are separating or divorcing. And there were, basically there have been a lot of significant changes that the federal government has made to the Divorce Act, taking into account a lot of the proposals and a lot of the feedback that family lawyers and advocates for survivors of gender-based violence had put forward towards the federal government. So these changes were supposed to come into place last summer in 2020, but because of COVID, they were just implemented in March of this year. And there are there's a number of like very significant changes that I feel like is important for me to mention. The first is that there has the language around child custody and child access has changed. So child custody basically refers to which parent has the legal right to make major decisions about the child's life. So that language of custody is no longer used in the Divorce Act. It's been changed to decision-making power or decision-making responsibility. At the same time, the language of access, which refers to visitation rights or ability of a parent to like visit the child and have the child visit them, that language has also been changed to now it's referred to as parenting time. And the reason for that change in language is I think the Canadian government recognized that the family court process was getting very adversarial, and using languages like custody and access made it seem like a win-lose situation where one party wins custody and another, wins access. So I think the government is trying to like encourage collaboration between separating parties into deciding child-related issues. And then the second really big change that's happened is that the Divorce Act has actually introduced a very robust definition of family violence. And prior to this, there actually was no definition of family violence in the legislation. So it's a pretty significant change. And I want to read out the definition actually, because I feel like that is the best approach to take. So the way that the Divorce Act defines family violence is any conduct from one family member to another that is threatening, that constitutes a pattern of coercive and controlling behavior, or that causes the other family member to fear for their own safety or the safety of another person. And in the case of a child, includes direct or indirect exposure to such conduct. And the Divorce Act even includes like a list of types of abuse that fall under the definition of family violence. So it doesn't just mention physical abuse and sexual abuse, but also goes as far as to include financial abuse, like withholding finances from a spouse or not allowing them to work, verbal abuse, psychological abuse, including intimidation, harassment, stalking. The definition of family violence also includes threats to damage property or even like hurt an animal. So it's a very robust definition, and the Divorce Act goes even further and basically says that the courts actually have to take family violence into account when they're deciding the arrangement in regards to the children. So the primary principle that the courts use when determining child-related claims is the best interest of the child. And there's a number of factors that the family law outlines, or the Divorce Act outlines, that the courts have to use when trying to figure out what is in the best interest of the child. And one of those new factors is specifically family violence. Is family violence occurring within the home? What's the nature and frequency of it? Is a child exposed to it, either in terms of directly being threatened or hurt, or are they witnessing their mom being threatened or hurt? So basically the Divorce Act changes have really recognized a lot of the feedback that family lawyers and, again, advocates, organizations like the Schlifer Clinic, have put forward to the government to say basically that the family law is failing survivors of violence. So I think the Divorce Act changes have really tried to try to provide some more support for family court judges to be able to make decisions that put safety of women and children or survivors of violence and children at the forefront of their decisions.
That was great. An amazing summary of these amazing, very significant changes. Really appreciate that, Ghania. Aisha, you want to add anything to what Ghania's already shared?
I think Ghania did an excellent job of covering that. But from a perspective of, both men and both men and women Muslim clients that I have, I find that the changes to the language really help when I'm having the conversations with them about decision making. For example, I represented this one Muslim man, and he was fighting his partner he kept saying custody, custody, custody. No, I want the children. And then I really broke down what custody really meant, and just going through the decision making. And I said, so, you know, you're both Muslim. And he said, yeah. And I said, so, you know, do you guys have a history of making decisions together? And he said, well, what do you mean? I said, well, did you guys both decide that your children were going to be Muslim? And he's like, well, yeah, of course, they're going to be Muslim. We're Muslim, they're Muslim. I said, oh, okay, so that's good. And then I went through a pattern of decisions that they had made because they shared the same faith that weren't really controversial between them. And I said, well, what are you really afraid of? What are you worried about, that if she's given sole decision making, that she's going to do this? And, you know, he really stopped and said, you know, no, I think she's a good mom. I don't think that she's going to do anything like that. And so really, just when it comes to the Muslim clients, I try to go through and go through decisions that they've made together in the past, and then decisions that I think that are going to be coming up in the future, and that, you know, maybe if they, for example, if there's a daughter in the picture, I talk about, you know, I talk about the hijab. I talk about, okay, is this something, if she's very young, I say, well, do you know, is this something that you would want for your daughter that you think that she won't? And, you know, I go through different things, issues that I think that may come up between them, that, and sometimes when you go through these conversations, people realize that they don't really have that many issues of decision making with their spouse. So I think that from a practical perspective, I think the language really helps when you're not using words like custody anymore, and you're using words and phrases like parenting time and decision making responsibility. It helps sometimes people realize that they have more in common than they do otherwise. And again, it always depends on the client, because even if they, you know, people do share in their perspective when it comes to certain decisions for the children, they may not have the best communication with each other. So that may not really manifest itself in the future the way that people hope. So just having those conversations, I think, really helps, even from my perspective, and even for some of the community workers that are listening here, just to really go, you know, to have those types of conversations would be helpful. So
just a follow up. So do you actually explain to them that there is no such thing as custody any longer in Ontario? Well, I mean, across the province, because it changes, you know, there was a federal law and then the provinces had to come, you know, to comply. So has that language completely disappeared when, you know, a separation agreement is being negotiated and the provisions in it? So how do you educate everybody that we're not talking about custody anymore? We're talking about collective decision making for the best interest of the child.
So custody has always been about decision making.
Right.
That's really what it's always boiled down to. It's just that the word itself is pretty contentious. So right. I still use the word because that's how I know people like that. I'm able to but I use the same word, but I unpack it, and then in my pleadings or my separation agreement, I don't use the word custody. I use the word decision-making responsibility. But when a client comes to me and says, I want sole custody, I unpack what that really means, and I explain to them that it's not about the child actually being with you all the time. It's about who gets to make the final decisions, the big decisions for this child. It's not going to be, well, you know, what's he going to eat today, or, you know, it's not the day-to-day decisions. These are the big decisions that you anticipate that you're going to have to make for this child. So I really unpack that word, and I still use that word, but I explain to them that we just don't use that word anymore, because that's what it really means is decision-making responsibility.
That's great. Very good explanation. So I'm going to now pick on Timothy, because we have this really interesting topic of the instant or the 30-second or 3-second divorce. It has come up, you know, in our conversations with Muslim women, where a woman contacted us and said that her husband divorced her on the phone, you know, informed her on the phone that he's divorced her. And we've had instances where the husband declares, I divorce you 3 times, or just pronounces talaq, 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 and says, now we're divorced. You know, marriage is over, you know, go and make your own arrangements to live, in fact. Or you can sleep in a different bedroom because now we're divorced. So can you tell us a little bit, Timothy, about the concept of divorce in Islam, and where did this triple instant talaq come from?
Well, there's a whole spectrum of interpretation about the idea of a divorce pronouncement, and what really constitutes three articulations of the intention to divorce. And most scholars would see an angry moment where he says, "I divorce you, I divorce you, I divorce you," as a first articulation and sign that there's a problem and the couple needs counseling, or that something needs to be addressed. And I would say too that there is a misunderstanding within the Muslim community that divorce remains the kind of the sole right of the husband or of the man. And so I know that there are questions that are coming up even today with regard to whether if a man refuses to grant a divorce as a punishment or as a torture for his wife so that she can't get remarried or she can't be free of him. There are, of course, mechanisms, even within traditional Islamic framework, for her to take some agency and to seek scholarly support and to win a divorce, even without his permission or consent. All of that is possible within a traditional Islamic legal framework. But unfortunately, many Muslims are not, of course, scholars of their faith, and they may not have any idea about any of these tools or any of these rights. And so then divorce is perceived to be the right of the man or the right of the husband. And so for a woman, if a woman is living in a situation where the man in an angry fit says, "I divorce you, I divorce you, I divorce you," and now you have to find a place to live, this is probably not a safe and nurturing relationship for her anyway. And so again, I mean, it's here that we need to think about religious models for her situation that may not have to do with keeping her in the house at all costs. So if she's in an abusive or a disempowering or a self-esteem destroying relationship in her home, then we shouldn't always be talking about reconciliation, or at least not immediate reconciliation. And so I think, again, the priority of getting her to a safe environment, to a safe space where she can begin to heal and rebuild and regain some energy and regain some power and some agency, I think this is critically important. And so Muslims don't always, or really hardly ever, talk about what we call a hijra model for a woman in this situation. That is a migration model of, as the Prophet migrated from an abusive, hostile environment in Mecca to a place of safety, to a refuge, we should be talking about for women who are involved in these kinds of disempowering and threatening and sometimes actually violent situations. And so there are some Muslims who think that if a man says, even a non-Arabic speaking man can pronounce these magical talismanic Arabic words, talaq, 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 that he doesn't even really fully understand, and neither of them speaks Arabic. They think that somehow mystically, magically, spiritually, the marriage is severed. And most Muslim scholars would say, no, that's clear evidence that there's a problem, but it's not a divorce. And so I think that women in that situation really need to be guided to speak to scholars who can at least contextualize the whole situation, and then perhaps even more importantly, can ask, are you okay? It sounds like things aren't okay at home. And so maybe we need to make sure that we ensure her safety and the safety of the children, if there are children, before we can even talk about marriage counseling or divorce proceedings. So anyway, so it's but unfortunately, a lot of Muslims grew up thinking that just as marriage is the right of the man, because in a traditional, a super ultra traditional Muslim marriage, she doesn't even have to be physically present. It's her representative who then offers, with her permission, who then can conduct the marriage proceedings on her behalf. And the man, the groom, is in the sole position of power saying, I accept. The offer has been made and the mahar has been given, and he says, I accept, and then the marriage is magically, enacted. And so when I do a nikah, when I do a marriage, there's nothing left to the imagination. Everything is explained in English and in Arabic, or however it needs to be explained. And you'll be surprised at how many people after a marriage like that, where everything is explained and everything is clear and nothing is left to the imagination, they'll come up and say, I got married 50 years ago and I had no idea what happened. I just knew that after, some Arabic was said, now we could sleep together. And so it's amazing how many Muslims really don't have any understanding of the rituals themselves. And that includes marriage and it includes divorce. They just know that, that they've lived through a marriage or they've lived through a divorce, but they have no idea how it actually worked or what the mechanism was. And so when it comes to divorce, I think there's a lot of unlearning that we need to do and a lot of community education that needs to take place so that people at least understand what the mechanisms are and what it entails.
So I think it's really important what you're saying, when they contact us and we hear that, that's our first question. So, that's supposed to be a very reprehensible, behavior. What happened, what led to it, and you have recourse. You should consult an imam. You should talk to a lawyer as well if you,
Right.
if they're so inclined. But that is not what a divorce is. Now, the other thing that will happen, and I know we don't have time to go into a lot of detail, but I want to tell you that there's a question that we often get from them saying, can I get an Islamic divorce? So yes, a woman is entitled to, to get a divorce. But she often insists that she's getting a legal divorce, a civil divorce, but she also wants an Islamic divorce because she wants to do do it within her faith. And then you explain what the process is, that yes, you can, and she will request, okay, so what form do I fill out to get a khula or seek a divorce? And that is, I don't know if the lawyers want to talk about that, but that is a very common request we get. Anyone want to talk about that?
Well, I'll just say that, we don't have a form bank within Islam where, this kind of divorce, that kind of. So this is, again, I think this is one of those cultural competence moments where the lawyer would say, okay, well, let's find someone within the community who can be a resource and an ally for us and help us understand the religious dimensions while we navigate the legal terrain.
Right.
In my practice, when I have encountered this issue, well, first of all, it's, the first thing is, for me, I recognize it as a form of abuse. It's a form of emotional and psychological abuse. And usually it's happened, there's a history or a context of the threat of that being used, like before it's actually done, like there's a threat of it being used like throughout the marriage. So I think for me, like, the first step is to do like a full scale like risk assessment to be able to see like, okay, is there anything else happening here? Any other form of abuse? To be able to figure out what are the immediate safety concerns. And then again, if the client wants, to be connected with a therapist, or she needs some other support, like, a meeting with a housing worker to figure out, her housing options, like I provide the appropriate referrals that way. The other thing that I wanted to mention about this is that I have encountered women that do believe that it's a valid divorce, like religiously, that they do believe that once that man utters those the words 3 times, it's a religious divorce. And obviously I'm not qualified to speak about the religious dimension of it, except to encourage the client and provide her with appropriate referrals to, religious leaders that can provide her, the proper guidance. But I do have to clarify for clients that a religious divorce is not a civil divorce. There is a specific process in the family system to get a civil divorce, and that can only be granted by a judge of a court, in which in Ontario is the Superior Court of Justice. And there is a procedure to follow. There are certain grounds for divorce, the most common of which is that the parties have to be separated for 12 months. And there's a host of other things that the court is looking at in assessing whether or not they will grant the divorce, including if there are children. The court wants to know, have arrangements been made for the children? What's the decision-making responsibility? Which parent has that? What is the parenting time or the access, the visitation schedule like? So I usually have to do kind of that explanation, because sometimes clients have this opinion that the religious divorce means that they're divorced, but that's not the case.
Yes, absolutely. Anyone else want to add to that topic? We're going to move on to another very controversial one. No? Okay, let's talk about polygamy. Again, something that we hear about, from women. So here are some of the scenarios that we've encountered. A woman will suddenly find out that her husband's already married. So either he has another wife here in Canada or somewhere else, or she's the first wife and he's brought another wife. And she doesn't really know what to do, because most women actually do know that in Canada it is a criminal offense. So they will contact us and they say, how could he do that? And more often than not, the marriage has taken place, by there is an imam that has officiated it, and the man will say, yeah, I had an Islamic marriage, and I'm entitled to do that. So maybe you could explain, Timothy, Timothy, you can explain the concept of polygamy in Islam, and then we'll talk a little bit about the issues that come up for Canadian Muslim women in polygamous families.
Okay, well, again, I mean, this is another huge topic, and there's been a tremendous amount of really intelligent discussion about this internationally within the global Muslim community. And it should be clearly stated that even in many Muslim majority countries, polygamy is very carefully regulated. And so it's not exactly like a freewheeling right for a Muslim man who's just ever eager for insatiable sexual variety. But the Quranic intentionality underlying the permission for polygamy, the Quran is an oral text which was revealed over a period of about 23 years. And so, like many oral documents, there are documents that began as oral documents and then later on became written documents. There's a great deal of repetition in the Quran. So we've got Jesus and Mary over here and Jesus and Mary over there, and we've got all this repetition happening in the Quran. In the case of polygamy, however, the permission is given in only one place, and it's given in a context that is really concerned about the welfare of orphans. And so we understand from traditional Islamic scholarship that these verses were revealed at a time when the community was under threat. There were battles going on. Husbands and fathers, some husbands and fathers were being killed, and the community had a challenge, and that is how, and in many cases, the bereaved wife and mother to go back to her family would mean to go from Medina, now a city of monotheism, back to her own family in Mecca, which would have been a reversion from monotheism back to polytheism, which would have been unthinkable for the community at that time. And so in an effort to try to care for those orphans and their mothers, the widows, the Quran gives permission not to marry the children orphans, but to marry their mothers as a way of taking care of those families. And so it's very consistent with the Quranic concern for orphans, for widows, for the vulnerable. It's very consistent with those Quranic principles. And so, it has nothing to do with male desire or testosterone or there are lots and lots of cheap and ignorant ways in which Muslims defend polygamy. I've heard, we said this last time too, that some Muslim men have said, well, in Canada they have, or in America, they have fornication, which is a sin. But God knew that that this was a problem for men, so we have polygamy, right? So we at least do it responsibly. But I have to say that when a wife discovers that that there's a secret marriage, to often a much younger woman in another place, or sometimes even in the same location, it looks like infidelity, it feels like infidelity, and it has all of the emotional and spiritual trauma of infidelity. And so when we're talking about polygamy, then it's the Quranic intentionality is as a way of taking care of vulnerable people, of orphans and widows. And the Quran says very clearly that, look, you're not going to be able to do justice. You're commanded to do justice, but you will not be able to do justice between them. And so it's really understood that the Quran, that the default in the Quran is an argument for monogamy. But in these extreme situations, it could be, license can be given for polygamy. That's unfortunately not how it's practiced in most Muslim majority environments. And so as with any system of law, once the precedent is set and it's given, then people can abuse and misuse that precedent for their own whims and their own perceived advantage. And so in Canada, the Canadian Council of Imams, and I'm very proud of this, they've made a very clear statement that in Canada, we we do not perform polygamous marriages. We do not engage in polygamous marriages. The law of the land, the civil code of the land, is a law that we do not violate in any aspect of our religious legal discourse or practice. And so, but that said, we know that these secret marriages are happening all the time. And one of the problems with the enforceability of the criminality of this is that these marriages are not registered anywhere. And so there's been no fraud to the state of Canada or in any court. There's been no fraudulent marriage license issued often. So what's happened that these are just sort of secret liaisons, which have been somehow, blessed in a kind of perverted way. And so that people think that they're legitimate before God. And so we know that not only have some imams, conducted these services, but we also know that some notable, even Muslim scholars who travel a lot have engaged in these secret marriages and have really not been held legally to account for their misbehavior. And so polygamy is actually it's a very important topic for us to understand academically, and it's very important for us to recognize that the permission is issued only in one place of the Quran and one and only place. And so the intentionality, a close reading of that text is really important. But unfortunately, in the way that it's practiced, it's not practiced in a way that is cognizant or mindful of the Quranic context or intentionality behind it.
Very much so. I'm conscious of the time. I know that we have a few more topics to cover, and then Barbara is going to talk us about the hubs. And then we want to at least have time for a few questions. And I know the questions keep on coming. So I just want to ask everybody, including Barbara, if you have a hard sort of end time of 4 o'clock, or if you can stay with us for another 10 minutes or so we could at least address some of the questions. May I get a thumbs up? You okay, Tim?
Yeah, I may have to just take a quick break for a couple of minutes and take care of one thing, but I'll be right back.
Okay, Barbara, how about yourself? I'm going to try to get you to speak before 4, but definitely, just need that extra time to get to the questions. So I did want to actually ask about the challenges to the women and children in polygamous marriages. So I'm not talking about the first sort of registered marriage. I'm talking about subsequent marriages of here in Canada, at least. Can you talk about what are some of the issues that the women might face? Who wants to go first? Aisha, do you want to start?
Sure. So in my practice, what I've seen is that women are scared, and they're worried that they're not going to be able to have any remedy at all because they're in this illegal marriage. But if they've been living with their husband for a minimum of 3 years, then they're considered a common law spouse. And then there are common law spouses do have remedies when it comes to seeking child support and spousal support. So that could be very reassuring to them that he would still have a responsibility to provide for the children, and also in many cases her, depending on their financial profile. So there is some remedies that are afforded to them under Canadian law that we could we could look into and go after.
Okay, Rania, do you want to say anything about it?
The only thing that I wanted to add is just building off of what Aisha said. Just making it known to the client that when it comes to the children, the marital status of the parents is not relevant. The court is looking at what's in the best interest of the children, that's a primary kind of analysis. And in terms of the best interest of the children, there is a list of criteria that the court can look at. But they're looking at what's the needs of the child based on their age and development. What's the child's relationship with each parent, with each sibling? Again, is there any family violence that the child directly experienced or was exposed to? What are the child's own views and preferences? So I think that's important to flag. The other thing is, if clients don't want to pursue a claim in the family court because they're worried about how that's going to be perceived, or if they're going to be able to get their claims addressed by a judge in the family court. I mean, they do have the option of like a private mediation or arbitration process, or like an alternative dispute resolution mechanism that's outside of the court process. But frankly, it's not really advisable in any case where there is an imbalance of power, or where the parties are on unequal footing. If there is a history of abuse or manipulation or lack of disclosure, or undue influence, misrepresentation by one spouse to the other, it's really not prudent to go through that remedy. And those remedies are also, you have to typically pay privately for those. So it's really people that have financial resources that can afford to go through that. And it does rely on private negotiation and settlement. So and while the courts can get involved, it's still a little bit of the Wild West type of situation in terms of alternate dispute resolution. So it's really just, I personally don't advise it for survivors of violence at all.
Okay. All right. So like I said, there's just so much more we could discuss. But I am going to move on to the next topic because we want Barbara to talk about the community hubs as well. So Timothy, this is a question about inheritance. In Islam, there's some very specific provisions for how inheritance should happen. And that's separate and apart, by the way, in a marriage, from the mahar. That does not play into the inheritance provision at all. Do you want to talk about that, Timothy? And then, we'll move on to Barbara after that. And also if Rania and Aisha, you want to add anything about inheritance? Go ahead, Timothy.
Well, thank you. this is another topic that has given rise to a whole spectrum of interpretations, from a very literal adherence to the Quranic dicta with regard to who should inherit what, and the Quran is actually quite specific about inheritance, or to looking more intentionally or symbolically at the question of inheritance. In pre-Islamic Arabia and in the early Islamic period, it was understood that a woman's wealth would be her own, and that a woman's wealth would never be used for the maintenance of the house or the welfare of the family or any of those expenses. And so and women generally did not live on their own, and so it was understood that a woman's housing and basic welfare would be automatically covered. And so in that environment, then men, sons, would inherit more than daughters, and that the wife's inheritance would not be a full inheritance from her husband, which then would later, upon her demise, be distributed among her children, but that upon the husband's demise, that it would all be portioned out, and that the wife would be given just a portion, a specific portion of her husband's overall wealth. That said, very early on, as the Islamic law developed, and as the schools of law emerged, and as Islam became a religion of empire and great sophistication, as opposed to a very simple monotheistic movement in Arabia, it was clear from early on that there were all kinds of legal mechanisms that people employed to get around these very specific and precise Quranic dicta, so that, for example, they could allot more inheritance for their daughters than for their sons, or they could give more to their wife. And so there were all kinds of mechanisms by which the wealth could be moved before death, so that what was left to be distributed upon death could be done formally according to the Quranic categories and according to the Quranic dicta, but that the real wealth had already been moved, and so now the daughters were getting salaries from a madrasa, or that the wealth had already been moved. And so I guess the interpretation then of the more holistic concept of inheritance has been in flux and fluid and much more dynamic than one would be led to think just upon a literal reading of the Quranic passages that deal with inheritance. And so like divorce, I mean, inheritance can also be used as a weapon of parents against children, or maybe weapons of between husbands and wives as well. And so I think inheritance is another one of those topics that a culturally competent legal professional would need to seek community counsel and support to try to figure out exactly what is intended here. But one of the very positive things about traditional Islamic financial planning is that everyone is encouraged to have a will. And so that means that people are encouraged from a very early age to think about their assets and to think about where they go and where they should go. And if people don't want to leave it up to a religious court when they die, then there are all kinds of things are possible with regard to the movement of one's wealth to one's children, to one's wife, or in the case of multiple wives, to one's wives and to their families. So inheritance is a much bigger and more fluid reality within the Islamic legal tradition than one might think upon a preliminary reading of the Quranic texts involved.
Okay, thank you for that great explanation. I don't know if the lawyers want to comment on it and whether it comes up in your practice much. If you can do it in a minute, that would be great. Otherwise, we'll move on.
It doesn't come up too much in my practice, and if it does, it's one of those things that I will refer out to another lawyer who practices in the area of wills and estates.
Okay, good. Same for you, Rania. Okay, thank you so much. I do apologize for my poor time management, but everything you all have said has been so interesting that I didn't want to cut off the conversation. And like last time, we could go on. We're going to probably do another seminar where we can, unpack some more of these concepts. Thank you again for enlightening us, and hang in there for the audience Q&A. But before that, Barbara, we're passing the podium over to you, our virtual podium.
Okay. Am I unmuted?
Yeah, you're unmuted.
Oh, okay. So I want to show a slideshow, and can you make sure that we can share this screen? And I want to thank everybody. This is such a wealth of information. And I just want to start by saying that the issues that we've talked about today apply to every faith group. Some of them sound specific to the Muslim community, but let me tell you, as a Jew, they are very familiar issues. And so this is very important. Okay, so what I wanted to, can you, if I do slideshow from the beginning, are you seeing, is it shared? I want to know that I'm doing this the right way.
So not yet. So can you click the share screen, Barbara?
Oh, I
let
have
us
to do
know
share
when we see
screen.
it.
Okay. Share screen, and I will do that. And I will do share. Is that
Perfect. We can now see it. Yes.
okay? So what I want to just start by saying is that really, apart from all of the legal concepts, the real problem is that there's so many obstacles to access to justice in family law for vulnerable people and for people who have limited means. Right now, we have 60 to 80% of people in family law that are self-represented. And Aisha knows that because Julie McFarlane, who's a friend of both of us, has really publicized that. And when people get into court who are unrepresented, they really are stuck. They don't have appropriate assistance, and they can end up being in an adversarial process, which is often more dangerous than processes out of court, even though I agree with the concerns about domestic violence for sure. But they often are in a more adversarial process that ups the level of animosity, and it can take years to resolve things. So it can take you 3 to 5 years to get through a court process. So as a result, I and a group of people have created community hubs for separating families. This is a national not-for-profit in order to help individuals navigate their own personal separation pathway. I'm really thinking very clearly about agency for the clients. Rather than imposing a solution, we are looking to them to find their priorities and their pathway. Okay, and we want to start off by focusing on safety. So let me just quickly go to, is it going to go to the next? Oh, here we go. Okay, so who are part of our community hubs? We've arranged a multidisciplinary group of wonderful professionals, lawyers, mental health professionals, financial professionals, from a range of backgrounds, who want to do things in a different way. They want an affordable, so people are agreeing to work at less than their Toronto Bay Street rates, but above the legal aid rates. And by the way, legal aid is not really available to anybody unless they're going to court. So there's a tiny amount of money that's available for people who are in domestic violence situations, but it is far from adequate. The legal aid process. Okay, we want a timely approach. Okay, and we are building these hubs across Canada. So for the community hubs, what we're looking to find out from people is, we're starting off with, why are they separating? Because people don't separate in order to have family law apply to them. They separate because they have a relationship breakdown. There may be issues of abuse, there may be issues of addiction, there may be special needs children, there may be the loss of a job. We want to find out what are they most concerned about? What are they hoping for an outcome? and what kinds of options have they thought about that they think might be workable in order to arrive at a good solution, and what process will best meet their needs. Okay, people can find us at our website, www.separationpathways.ca, or from the Family Law Portal, which is a free portal that we created through the Legal Innovation Zone at Ryerson that helps people understand what the issues are and what information they need. Our Separation Pathways website is currently under renewal. We're updating it because we're going to be offering our services online. Given COVID and given all the difficulties people have, we're going to be, these services are going to be available to people across the province online. Okay, and there are 4 different steps here. I'm going to take you through what the community hubs are offering. So first of all, there's an online intake questionnaire, and if people don't have computers, they can call. But what we're looking to find out is some basic information about whether people are still in the same house, do they have children, and whatever. Our first primary question is, are they safe? And for people who are not safe, the Barbra Schlifer Clinic or Luke's Place or whatever are going to get an immediate transfer. They're going to be connected to deal with their domestic violence issues. The second screening is, are they already in court? Has somebody started a court action? If somebody started a court action, then we're going to connect people either to legal aid, find out if they have a lawyer. We have a partnership with JusticeNet, which offers low-cost legal services from a variety of perspectives and across the province. And then if those 2 things, if there's not a safety issue, if there's not a court proceeding, what are the clients, what are the callers' primary issues? Are they emotional? Are they legal? Are they immigration? Are they housing? Do they need retraining in order to be in the workplace? We want to find out what they need. And if safety isn't an issue, then what our service is basically a triage service. We are looking to offer people a low-cost, fixed-price planning meeting. They get up to 2 hours with a qualified professional, hopefully a professional that is in line with what their priorities are, not for instant advice, but to really look at what kind of information would you need in order to address your particular issues? Where can you find that in a cost-effective way? What kind of options have you thought about that might be reasonable to achieve your goals? And what do you think your partner would say to those options? And then to give people a list of referrals to the appropriate kinds of resources. And okay, and the roster of professionals would include legal, mental health, financial, dispute resolution, mediation, collaborative law, arbitration, whatever seems to be reasonable based on their situation, or whatever else seems to be a necessary. It could be to a person of faith leader. And what we're looking for is partnerships. We're looking to have lawyers from different community groups so people feel that they can talk to somebody they feel comfortable with. We're looking for those people to be on our roster, or community agencies that would provide the kind of counseling or financial assistance or addiction counseling or children with special needs. We would like people from different community groups who would be willing to help our clients. And we've already had over 40 clients come through our service, and they are a significant number of Muslim, people of color, unemployed, whatever. Okay, so that's enough for me because we're running out of time. Okay.
Thank you, Barbara. You did that in record time. And I would be remiss if I didn't tell the audience that Barbara is a very precious and very hardworking partner with CCMW for a long time. And she's been our champion and advocate. And so we really appreciate it. And in fact, she is Dr. Barbara Landau. of course, a lawyer, a psychologist, and mediator. And she is the leader, the president of the community hubs for separating families, eminently qualified to do what she's doing, but she does so many other things and wears many hats. So we were really glad to hear from you, Barbara. Thank you so much.
Thank you. Thank everybody today.
Very good. So I know I said that we give another 10 minutes to everybody for the Q&A. We may not be able to get to each and every one. One of the people asked multiple questions, so maybe we can address your questions all at once if it's possible. Over to you, Sabrine. You are so good at moderating these questions and answers from the boxes there.
Okay, let's do this. That was an excellent panel. So let's go through the Q&A. So we have a few questions from one individual. I'm going to ask them all together as Nazhat requested. And if you'd like me to repeat anything, I definitely will do that. So the question starts off with, hello, my friend left her abusive marriage and is in court for custody. She will be applying for legal divorce as it's been more than a year. She also wants an Islamic divorce and her meher, but her ex refuses to give her an Islamic divorce to punish her so that she can never remarry. And he refuses to talk to an imam that wanted to mediate an Islamic divorce. Him and his family are not God-fearing and refuse to fulfill his Islamic obligations. How do we go about this? This individual continues and says, do you accept new clients? She's on OW and on legal aid, currently going through a custody battle that he keeps extending through lack of cooperation, and he doesn't want to provide any kind of financial support. Again, this builds on Barbara's point on how long these court battles can continue. He is a refugee and married her just to get permanent residency through inland spousal sponsorship. There's no matrimonial home. He is emotionally abusing her by not giving her an Islamic divorce and meher, and no child support either. And they continue. Is it okay if I continue, or do you want me to pause here?
Sabrine, maybe we should pause because those two questions were about the same individual, and then we can go to the other questions.
Okay.
So I don't know if Barbara, Aisha and Rania want to respond to that issue. We actually discussed this whole idea of an Islamic divorce and how the person will probably not do it because he doesn't want her to actually have that agency that we discussed. So who wants to tackle that?
So I think if this person, and again, I'm just here to give some information. I'm not here to specifically, give legal advice. I just want to say that, I would try to connect that person with some different imams to see if maybe she could, figure out her grounds for a khula and her right to ask for a divorce on her own. If this case is already in court and she's already on legal aid, I'm assuming she already has a lawyer. So it's very difficult to obtain a change of solicitor with legal aid, but that would be something that if she wants to change her lawyer, then she would have to do that first before any other lawyer would be in a position to take on her case. So that's a bit of a complicated part of it as well. And then I think, like not specific to this person, but in general, whenever I see power imbalance like this, I start to look into some of the remedies that I have as negotiating tools to start the conversation in my client's advantage. So I think that just understanding the whole picture so that you could address the person's goals, what they're trying to seek. For example, I had a client where I represented the man, and he was just being very reluctant about giving her the Islamic divorce, and we had this conversation, and I said, well, why? Why are you doing this? Like, why does she have to keep on asking? And he said, well, I want her to, I feel as though she's rushing this. Mind you, she had moved out, and it may have been, and he suspected that she started a new life with a new partner. So he said, I just want to give our marriage a chance, and I wanted to just go through the process and talk to somebody about the steps of possible reconciliation that I know that the imam that I'm talking to is suggesting. Now, even in my practice, I have to sign off on that as well. Under the Divorce Act, I have to ask people, is there a chance of possible reconciliation? I don't necessarily, that doesn't mean I'm implying that you should reconcile, but I have to go through that step as well. So, anyway, the point is that I had to recognize, okay, it was really important to the opposing party, in this case, the woman, that she get the Islamic divorce. And on his end, it was very important to him that a parenting plan be worked out where he had equal parenting. So again, you have to look at what both parties are seeking, and then you have to sort of come up with a plan to negotiate this. And then he ended up giving her the Islamic divorce, but we were able to have a conversation then moving forward past that. So I think with that, sorry, Barbara, you're saying something.
Oh, 1 second. I just wanted to say that just as in the Jewish faith, a man can't hold a woman hostage by refusing a get, which is exactly the same thing. Wouldn't the same apply? I mean, isn't that part of our legislation? So in Canadian law, you can't be held hostage.
Right, exactly. And then that's something that I do go over with when it comes to under Canadian law, but it's when the parties are specifically seeking that the other opposing party give them the religious divorce.
Yeah, but that get is a religious divorce.
Right.
It's the same thing.
I understand. And that's why it's important for them to have these conversations with the imams to say that, this is what I'm seeking and this is the reasons, and being able to ask for that khula, right? I mean, under Canadian law, you don't need to have a reason for a divorce. There's no, as long as you satisfy the requirements of being separated for a year and a few others that go into that framework, then that's it. One person can ask for a divorce, the other person can't hold the other person hostage. But under Islamic law, sometimes these people are under the assumption that they are being held hostage. He's not giving it to me. So what do I do? Right. And that's in that conversation is when I look at the bigger picture and see, okay, what are the other issues and how can we address this?
Okay.
There, just to clarify too, that there are, there isn't just the khula, there's also, the fasakh, the annulment, right? There are other mechanisms within Islamic law by which he does not have to be in agreement. He does not have to be interviewed. But there are ways in which, and it sounds to me as if this marriage may be an excellent candidate for annulment, which would mean that she would have to just interact with scholars and provide, as much evidence as she could, and then the marriage would be considered, it would be declared, it would be pronounced annulled, and then he would be informed. He would not be consulted in the process. So the perception of being held hostage is precisely that. It's a perception. And so again, this is another area where Muslims need to be educated about the tools, especially women need to be educated about the resources that exist even within very traditional sectors of their own faith.
Thank you very much. If we can continue, Barbara, did you want to add something?
I just want to add one sentence, and that is I really liked what Aisha said about finding out what the man was really fearful of. I mean, on the one hand, it sounded like he was hanging on to the marriage, but in fact, he may have been hanging on to a relationship with his children. And virtually everybody who calls our service, our community hubs, needs a parenting plan. They don't know what a parenting plan is until we talk to them on the phone and say, do you need some help in working out how you're going to maintain contact with your children? Oh, yes, a parenting plan would be a great thing. And that just settles everybody down and helps them to focus on their children's needs and get off of all their anxiety about hanging on to the marriage, which is not likely to continue to work. Okay, that's all.
Thank you very much. Thank you. I'm going to go on to the next question, which reads, Can you still get a civil divorce if marriage is not registered?
No,
No.
That's just a simple answer, no, because it was not registered, so therefore there's.
not a marriage,
Yeah, it's not a
Not a
marriage.
marriage.
not a Canadian marriage, not a Canadian marriage.
Okay.
Awesome. So the next question reads, why is it that an abused woman is asked to leave her partner because she's asked not to tolerate an abuser? However, a child is essentially legally forced to still have a relationship with this abusive individual. Why do the courts give access and custody to abusive partners, especially if the child is a female?
I haven't had a situation where it's mattered what the gender of the child is, so I'm not sure what that means really. Yeah, this is a really difficult part of the process, and you really have to look at each case to see what kind of harm has been caused to the spouse in the presence of the child. Or ought to have been in the presence of the child. So just to demonstrate that the father or the mother, what kind of impact they could have on the child if parenting time was to continue, whether it be unsupervised or supervised. So there is a bit of a burden of proof there, in the sense of bringing that out and demonstrating that, whether even the child, if you. A lot of times I suggest my clients to seek therapy for the children, so that we could get a little bit more insight into what this child actually wants and needs and feels as well. So there's a lot of work to do in those cases to really understand the relationship between the child and the spouse. Barbara?
I just want to say there's been a growing interest, and certainly I support it, in looking for a voice of the child in the proceeding. And it depends on the age of the child and their ability to express. But I find kids as young as 4 are pretty articulate about what their needs are, and then what kind of supports would be needed in order to repair the relationship, if it can be repaired. And the other end of the spectrum is sometimes parents will make an arrangement that the child spend a lot of time with an abusive parent, and the Children's Aid Society can be concerned about that. And the Children's Aid Society may end up taking custody of a child where there's been an inappropriate lack of safe planning for the child. So the new legislation is much more articulate about the best interests of the child and what would be reasonable in working out a parenting relationship.
Thank you. Thank you. It seems that time is never on our side, so I'm going to skip through some of these questions. One reads, according to Islamic creed, could I limit my future husband from marrying more than one wife prior to our nikah? Every time I express my opposition to polygamy, I am told that I cannot demand that my future husband never bring home a second wife, on the basis that I will be violating his divine rights. What about my rights, though?
How about a second husband for you? I mean, an alternative husband.
Sometimes, in the Abrahamic religions, sometimes as we're pondering the mystery of being created in God's image, we make the mistake of recreating God in our image. And so divine right, the use of the word divine right here is it's tragic, but it's funny at the same time. Yeah. The man does not have a divine right to multiple partners that are sanctioned by God or by the angelic ranks. There is, again, as we spoke, there is a Quranic license given within a very specific kind of circumstance that is all about orphans. It's not about men's divine right. So what this is more of a matter. Multiple marriage in the Quran is more about social responsibility than it is about the rights of man. And when I say the rights of man, I mean literally the rights of the male. And so you absolutely have the option in creating your certificate, your agreement of the nikah, to stipulate that if indeed he chooses to take another wife, that the nikah is finished, right? That this is a condition for immediate annulment of the marriage. And so I think it's really important for couples to have these conversations before marriage. Often couples aren't even aware that this might even be, in the wildest dreams of the man entering the marriage. But I think it's an important thing to have these conversations before one enters the marriage. And then of course you have the right to stipulate whatever you need to feel secure and comfortable in that, even in that religious contract of marriage. Absolutely.
But in order to avoid a secret relationship, like him, if he's that open about what his sexual plans are, I would suggest you think about the marriage itself.
Thank you, Barbara.
And by the way, in our Muslim marriage contract, the sample, there is a clause that the spouse will not take on another wife. So you can spell it out right in the contract. Sorry. Keep going, Sabrine, because we're literally out of time.
Yes, I know. Sorry. So as soon as you all want to cut me off, I will. Okay. So one person asks, how does prenup work Islamically and legally in securing women's rights?
I think Islamically, I mean, it's absolutely within the rights of both partners to enter into a prenuptial agreement. But I can't really speak to the. I would assume that it works Islamically in the same way that it works legally, right? It's an agreement. It's a contractual agreement, and it's written and signed and witnessed, and yeah, I would just assume, but I'll let the lawyers speak to that.
Anya, Aisha, anything further?
No, Timothy, we pretty much said it right on. I mean, it's just, I would just create a marriage contract, like a prenuptial agreement, where I would go through the clauses pertaining to property, pertaining to children, pertaining to spousal support. I just would go through all the elements of the contract, and I would put that in there. So I've had actually women who wanted to put in there that they didn't want, they wanted to make sure that any property that they acquired during the marriage was their own and it would not be subject to equalization. So that was something that I saw that they came to me and said, well, it's my Islamic right. I can keep my property and I have my property. So I want to make sure that's in the marriage contract. So I put that in there. So it's just, these are the clauses that you can create in the marriage contract.
Great, thank you.
Thank you. I think that is it. We have a question that asks if the recording of this webinar will be posted. The answer is yes on the CCMW's website. But I think that is all for the Q&A. There's a couple that I missed, but they were attached to the general question that was answered. So I do want to extend my thank yous, and I'm going to pass it along to Nazhat to give the final closing remarks.
Yes, I mean, there were some questions that had to do, sorry, this cat is appearing before the screen here. There were some questions about, what if the first marriage or second marriage took place overseas? I mean, if that marriage, wherever it took place, is recognized in Canada, and the person, immigrated here on the basis on the basis that the person was married, regardless of where the marriage took place, the person's married. But if he goes and gets married secretly somewhere else in the world, it's way more complicated. And maybe we can come back to that another time, because that's actually a very common scenario. And then the recording will definitely be available. So watch out for it. We will have it available on our website. And Faduma, you asked, can you use a marriage contract as a legal contract? Yes, as long as it meets the conditions of a contract, that is, it's written, it's signed by both parties. So there's certain, in fact, if you consult our Muslim marriage, if you consult both our Muslim marriage contract kit and also our booklet on domestic contracts, there's a lot of good information about what that contract can look like. So once again, I want to thank everyone. I do apologize for the fact that we went on, but just as last time, it was such a full session and so much information, and you were all just superb, just excellent. So we know you're very, very good at what you do, and that's why you are here today, because you are special and you're specialists, and we are grateful to you for giving us your time, and to our audience for being here. And also I want to thank Sabrine, because she worked really, really hard to organize these two seminars and get everybody, all the panelists organized and everything. And I also want to give a shout out to Iman, who has been supporting us technically. And of course, the rest of CCMW for supporting this particular initiative. So that's it. Congratulations. I think it was really worthwhile.
Great, thank you.
Thank you.
Thank you.
Thank you. Bye-bye.
Assalamu alaikum.